Welcome to Washington Legal Foundation's program. My name is Glenn Lambie. I am Executive Director and Vice President for Legal Studies for Washington Legal Foundation. It's a real pleasure to have everybody with us today. Appreciate you taking the time to join us for this 1 hour discussion about the Supreme Court. This is our 37th annual briefing on the upcoming term. I think it's fair to say a lot has changed with regards to how the court is and operates over the last 37 years. I think especially the number of granted cases that are available to discuss probably were higher 37 years ago than they are today. However, we do have some very interesting cases to discuss that are very much within the orbit of WLF's mission. We are amicus curiae in 5 of the granted cases we'll talk about today. We also filed in support of certiorari in 2 of the matters that the justices were scheduled to consider yesterday in their so-called long conference. And we've also filed in 2 others as well. Some housekeeping before we introduce the speakers. This program is being recorded. If you have any questions, please do throw so with the Q&A function down below, and we will get to them at the end of our discussion here. Without further ado, I will introduce our speakers. Joining us today is Michael Kenneally from the law firm of Morgan, Lewis, and Bockius, who is an appellate lawyer who helps clients tackle complex legal issues throughout all stages of litigation. Before joining the firm, he was a clerk for Antonin Scalia and Samuel Alito at the Supreme Court, and for Neil Gorsuch at the U.S. Court of Appeals for the 10th Circuit. Also joining us today is Sean Marotta, who is a partner in the Washington, D.C. office of Hogan Lovells, who has argued at the Supreme Court and in state and federal courts across the country. He's also briefed cases in the Supreme Court, Federal Court of Appeals, and state intermediate and courts of last resort. And he's a fantastic follow on Twitter if you do that sort of thing. And finally joining us is Elbert Lynn, who's a partner in the Washington, D.C. office of Hunton Andrews Kurth, where he chairs the issues and appeals practice. Before joining the firm, he was the Solicitor General of West Virginia, a position he was appointed to in 2013. What's especially notable about Elbert is that he's clerk for judges on every level of the federal judiciary, for Supreme Court Justice Clarence Thomas, for 11th Circuit Judge William H. Pryor, and for U.S. District Court for the District of Massachusetts Senior Judge Robert Keaton. I think a good place to start our discussion today of granted cases is with the cases that's scheduled to be argued first on the first Monday, Sackett versus EPA. Our friends at Pacific Legal Foundation have been fighting on behalf of the petitioners in this case for many years, and this is the second time that this case has made it to the High Court. Elbert, why did the justices grant review in this case the second time, and what's at stake in second?
Sure, thanks, Glenn, and thank you to the Washington Legal Foundation for having me here. It's always fun to be on these kinds of panels, as we were saying, in Supreme Court preview season with friends that I see a lot more of about this time of year. So Sackett, I mean, I think there's two reasons, and one is the substance of it, which I'll turn to in a second. And the second is, as many of the folks on this call know, the court kind of likes repeat cases, right? I mean, there are so many cases where they've taken them before on one issue and then they take them again on a second issue. You know, here, this is the fact that this is now back kind of overlaps well with the issue, the substantive issue, which is the meaning of waters of the United States under the Clean Water Act. So basically, the question here is the Clean Water Act jurisdiction of the United States extends to navigable waters. Navigable waters is defined as waters of the United States. So, you know, what does that mean, right? I mean, that's sort of the operative term that determines, you know, what sort of things over which Clean Water Act jurisdiction extends. And the issue here is that the meaning of waters of the United States has been hotly debated for basically ever since the Clean Water Act was enacted by Congress. And this is this really long running debate where you've had agencies try to define the term in different ways. You've had the court enter the debate a couple times. And really the biggest sort of piece of this puzzle is the court's decision in Rapanos versus United States. And in Rapanos, what you had there was a 4-1-4. So you had a plurality decision written by Justice Scalia, you had a concurring opinion written by Justice Kennedy, and then you had a dissenting opinion by Justice Stevens. And the problem is that courts have struggled, as have the agencies, in figuring out which one of those opinions is controlling, because it is not clear, and I think most people agree on this, that one of the opinions sort of fits neatly within the other. So you don't have concentric circles or one circle kind of within the other. You have two sort of overlapping circles, right? The Venn diagram, and so it's sort of not clear which one controls. The Scalia plurality sets forth one definition of one understanding of waters of the United States, which has to do with relatively permanent flow and surface connections between wetlands and waters. Whereas Justice Kennedy's opinion, where he wrote for himself, adopted something called the significant nexus test, which really just the question is there a significant nexus, and he defines that as having where a wetland has a certain effect, biological, physical, ecological sort of effect on waters. And so you have this opinion, and in the now 16 years since the Rapanos decision, courts have disagreed over which is controlling. You had the Obama administration promulgate a rule that kind of tried to adopt sort of the Kennedy test. The Trump administration then repealed that rule, and that was challenged and it was stayed. And then the Trump administration repealed that rule, came out with their own rule that kind of adopted the plurality with some tweaks to it. And then that was challenged and enjoined. And then the Biden administration has, now in the process of doing their own thing. So what you've got, sort of the short to get to answering your question directly, Glenn, why did the justices grant review? There's a mess, and it's a mess sort of the court's own creation. Now, part of it is that, waters of the United States is what does that mean, right? Maybe there's some legitimate question over it. Do we even know? Can we figure out what that is? But the other thing is you've got, an opinion from the court that purported to try to decide that question, but it didn't really give, a controlling opinion. And so, a lot of the cert petition and the amicus briefs on cert were focused on this, look, Rapanos has generated all this confusion. The court created this confusion. The agencies haven't been able to figure it out. Regulated parties are in states that have to implement, the statute, have been yanked back and forth, and it's time to sort of settle this. And so I think that's really the question. And I think, there's a couple interesting things that I'll just sort of throw out there really quickly. And I know we're gonna hear from Sean, who submitted an amicus brief on this, is I think, most people expect that it is ultimately going to be kind of a question of, which Rapanos opinion do we adopt? That 3 justices who joined the Scalia plurality are still on the court. Scalia, the chief, 4. Is that right? I'm now miscounting. And so, the question is, you've got justices who joined the Scalia plurality still on the court. So it does seem like the question is going to be, which one of these opinions do you adopt? But our friends at the Pacific Legal Foundation have raised some issues that go beyond the scope of the Scalia opinion. And so it'll be interesting to see whether the court is interested in getting into those other questions. And the other backdrop to this, as I mentioned, is that the Biden administration is continuing to work on a rule that would purports to define waters in the United States. As I understand it, that rule is now before OMB. And so, you've got that piece of it too, which is that, the court is, poised to weigh in on this, but then you've got the agencies, working in parallel. What does the court make of that? How much of a deal does the federal government make of that at oral argument? So that'll be interesting to see as well.
Elbert, as Elbert mentioned, Sean, you and Kate Stetson did a brief for the American Petroleum Institute. Second, what's their interest in the case, and what did your brief sort of focus on?
Yeah, we filed on behalf of the American Petroleum Institute, the Association of Oil Pipelines, and our friends at the American Gas Association, all of which talk about the need for clear and predictable rules in this area. What is a water of the United States has a lot of regulatory import for whether you're going to either your local state regulators or if you're going through the federal regulatory process, which is often run through the states through delegated authority through EPA, but at the same time is a sort of whole different kettle of fish. And the problem, I mean, this is sort of a piece of what's been in the news lately, which is just the difficulty of getting anything built in this country. Because you have so many permits and so many authorizations that you need to move forward with something, any ambiguity in the system can be used by environmental, non-governmental organizations, landowners, others opposed to development, to find a way to find 20, 30, 50 veto points for your project by tying up in the legal system literally anything that you need to get your project done, because it's often not so much the integrity of the water that they're looking out for, but rather in opposition to the project as a whole. So this waters of the United States issue, among others, is one where, for instance, if you need a permit and you don't go get it, there could be tremendous fines and citizen suits brought against you. Or if you don't need a permit, but yet you have to go get one out of a sense of compliance, you've slowed down your project and subjected it to a whole set of legal challenges. So it's really a no-win situation for people stuck in this ambiguity. You have so much to do to build a pipeline or an electricity line or anything else that requires displacing waters of the United States, even in very small amounts. And as a result, having clear rules in this area is going to be essential to get infrastructure back on track.
John, we'll move on to National Pork Producers Council versus Ross. In that case, the court will consider a California law that allows the sale of pork in the state only if the pig's mother was kept in a group pen with at least 24 square feet of space per sow. As the petitioner and many of the amicus that were supporting the petitioner argue, though, including one in which you were involved, Sean, the case has implications beyond the so-called other white meat. Why is that?
So I think it's two big things for the court. The first is, what is the future of the Dormant Commerce Clause? There is no more clause or concept in the Constitution that has been declared dead or about to be dead or is on its way out than the Dormant Commerce Clause. Justice Scalia very famously believes that there is no Dormant Commerce Clause. Justice Thomas shares that view. And so the question becomes, is this going to be finally the case that kills the Dormant Commerce Clause? In part because you think there may be justices who don't like the Dormant Commerce Clause generally, and there may be justices that are sympathetic to California's ability to regulate in this area, and can those justices form a 5-justice majority? On the other hand, however, and this is really the second implication of the case that we talked about in our brief for the National Association of Manufacturers, who are my favorite client, and not just because they're on the webinar today, is that what is the implication for the ability of states in sort of a supercharged culture war environment that you can use your power to control things that are sold inside the state to really influence the manufacturer or conditions of manufacture that occurs in other states? So in California, California says, look, we're not telling you, Iowa, how to produce pork. All we're saying is if you want to sell pork in California, you got to do certain things. It has to meet certain characteristics. But the response to that is that no one sells California pork by itself. It's that you have an integrated supply chain where pork goes out throughout the United States where it's needed. So everyone's going to have to change their change their production methods to meet sort of the least common denominator to the extent you can even find one. You know, the concern here is that, for instance, there is not uniform agreement that the California, you have to be able to stand up, turn around and sit down, or do the hokey pokey, as I know one of the clients calls it, in your group pen is actually the safest way to raise sows. There are others who believe that the current practices are safer for the animals and they're safer for the workers that tend to the animals. And so if you have one state that says you have to do this and another state that says you can't do this, how are you as a producer going to meet both unless you really start making major changes to how you track and carry out your supply chain? So if you think about what the Dormant Commerce Clause is supposed to do, which is create this national market, this seems to sort of be in, just at the center of it. I mean, decades ago, the comment was made that it's obviously unconstitutional that if one state could say what the minimum wages are of somebody else in another state. So for instance, anything that's sold in California must have a $15 per hour minimum wage the workers must receive, or else you can't sell. But that's telling other states what they have to do. But here where you have the combination of, I think, hostility to the Dormant Commerce Clause and plus perhaps sympathy towards California's approach, you wonder if you can get strange bedfellows to add up to 5. By contrast, you have the justices who may not like the Dormant Commerce Clause, but probably really don't like California's overreach into other states. And the question is how that all shakes out. What's also weird about the case is that there are other cases that kind of presented the exact same issue from the California context. There was foie gras that came up on basically the same type of issue, and everyone thought, I think, that this case was not going to be granted, much as like those cases weren't. But they took this one after relisting it close to like 10 times. And so I think the question for a lot of court watchers is, why did they take it? What are they going to, what's the message that somebody thinks they're going to get 5 votes for, and it's really anybody's guess?
Not surprisingly, given the stakes, 39 states plus DC participated as amicus curiae in Ross, 25 on national pork side, 14 plus DC for California. What do you think is behind those alliances and their positions, Elbert?
Well, I think it is it's sort of from a legal realist standpoint, right? I mean, it really highlights kind of what the issue is here. If you look at the makeup of the states, the ones that are supporting national pork are red states, and the ones that are supporting California are blue states. And I think what it highlights is that, this case really is about some states feel, want to protect the ability to influence policy in other states. That's what's going on here. I don't think that California can put whatever lipstick on the pig that they want to, right? But it is clear that that is what's going on here. Now they've got, as Sean said, the legal question about the Dormant Commerce Clause is a really interesting one, and one where you've got, maybe some of those justices who might disagree with the idea of, certain states trying to dictate national policies, set a higher floor, if you will, right, from a regulatory standpoint. But they don't necessarily think that the Dormant Commerce Clause is a thing, because there literally isn't one. But I think what those states, what the amici briefs show is that you've got, certain states that tend to be the kind of states that favor either one, sort of more regulation or more nationwide regulation, or at a minimum have policies that tend to have policies, views that would be above the sort of regulatory level of the red states that are on the other side. And they're the ones, I think, who are, they've come in and said, like, whoa, what this case is really about is making sure that we don't have our blue state friends trying to tell us what to do in our state. So
it seems from looking at the docket this term that the states are very involved in cases this term. I don't know if more than ever, but have you, Elbert, seen a sort of trend towards more state involvement in cases as amicus curiae?
Yeah, I mean, I think the short answer to that is yes. I will freely admit that I have not done an empirical study of it, but I think if you just anecdotally and as an observer of these cases, I think most people would say that they have seen an uptick in states being involved in as amicus and as parties in Supreme Court litigation. I suspect that there's kind of two reasons for that. One is it coincides with the rise in the profile of state attorneys general and the sort of somewhat recent trend. I mean, it's now no longer recent, which makes me feel really old, right? But that goes back to sort of the beginning of the Obama administration and states suing the federal government early and often, right? Texas first, then California under Trump, and then now kind of back to Texas and some of the red states under Biden. So there's that. And then the second is you have this, growth and rise of the state solicitor general, where you're getting a lot of sort of SCOTUS nerds like those of us here on this call going out to the states and becoming state SGs. And there is going to be natural, I think, kind of bottom up, right, pressure from those state SGs to say, look, let's get involved with these things. These are these big important issues. This is the kind of thing that I'm interested in. We want to do the domestic issues, obviously, in the states, but the SCOTUS stuff, is really interesting and important. So I think that's probably the reason why you're seeing it happen.
Thanks very much for your insights on that. I think you definitely have a unique perspective on that. So the artist still known as Prince and another notable late artist, Andy Warhol, are involved in another case on the November argument calendar. 37 amicus briefs were filed in this case, which involves what it means for a work to be quote unquote transformative. Michael, thanks so much for volunteering to talk about what looks to be this term's Google versus Oracle.
Thank you, Glenn, for having me here on this very distinguished panel. I'm looking forward to talking about this case, Andy Warhol Foundation for the Visual Arts versus Goldsmith. Before I jump into the facts, though, let me just set the table a little bit with some background for those who don't have the Copyright Act committed to memory. So the Copyright Act, as most people know, gives authors of original works of creative expression certain exclusive rights for the duration of their copyright term. And those rights include, obviously, the right to reproduce the work, but also the right to distribute, to perform or display it publicly, and as relevant here, the right to prepare so-called derivative works. So think of turning a novel into a screenplay. The screenplay is derivative of the novel, or writing a sequel to the novel. That would also be derivative. And those would be the kinds of activities that would generally require the copyrights owner's consent because of this derivative works right. Now, the tension in Andy Warhol, the case arises because these exclusive rights are not absolute. And in particular here, there is the fair use doctrine, which is an ancient doctrine going back to Joseph's story. So it's very old, but is now actually codified in the copyright statute. And the fair use doctrine says that otherwise infringing uses are okay if they're done for purposes like criticism or comment or news reporting or teaching and research, and then lays out 4 factors for courts to consider. And those are the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect of that use on the potential market for the copyrighted work. And as Glenn mentioned, the Supreme Court dealt with this doctrine just about a year ago in the Google versus Oracle case. But there, the nature of the copyrighted work was very different. It was some computer code. And before that, the Supreme Court hadn't really taken up this doctrine since 1994 in a case that dealt with a Two Live Crew parody of Roy Orbison's Oh, Pretty Woman. And now the court is coming back to give some guidance on how to resolve this dispute between the Andy Warhol Foundation and a photographer named Lynn Goldsmith. Goldsmith is a photographer, especially of rock and roll artists. And back in the 1980s, before Prince was really a huge deal, she took a series of photos in her studio. And then in 1984, after Purple Rain came out, Andy Warhol was asked by Vanity Fair magazine to make a cover essentially for the magazine and he used his famous silk screen method. So Glenn, I have a couple of pictures here to kind of liven this up a bit. So if you could go to the first of those, I'll show you. I think everybody's probably seen this kind of thing before. This is Andy Warhol. He takes a photo here of Marilyn Monroe, and then makes this whole series of pictures through paints and silkscreen and all that. And so he did the same thing here with prints and a photo that Miss Goldsmith took. If you go to the next slide, please. So here on the left, and these are all pictures from the party's briefs. I don't have just like a collection of Prince memorabilia or something. So here you have on the left the photograph that the photographer Miss Goldsmith took, and then a whole series of the silkscreen images. And if you look at the right-hand column of those silk screens, focus on the second from the top, the one that's all orange, and the one on the bottom right-hand corner that's purple and orange. Okay, so in 1984, as I mentioned, Vanity Fair commissioned a cover by Andy Warhol, and he got a license from Ms. Goldsmith to use this photo, and the picture ultimately run on the cover of Vanity Fair in 1984 was that purple image. Here you have it right here. Then fast forward to 2016, Prince passes away, and Condé Nast decides to run a commemorative edition. They then use one of the unpublished images from the Warhol series, the fully orange one, and they run it. They do not get a license from Ms. Goldsmith. And so you guessed it, we have a lawsuit. So that's how we ended up where we are today. And the question really before the Supreme Court in this case is about whether the first factor in that fair use test, the nature of the purpose and character of the use, is sufficiently transformative to justify using this photograph for the underlying silkscreen process without getting a license. And the foundation argued that it was, much like the song parody upheld in the Campbell case from 1994. And they quote language from Campbell that says that a use is transformative if it could reasonably be perceived as conveying a new meaning or message. Now, on the other side, the Second Circuit and Ms. Goldsmith and the Solicitor General all argue that you can't take that standard too far, because if you did, then pretty much any derivative work, the thing we think of as requiring a license, like the sequel to the original novel or the screenplay or something, that would be transformative too, of course. And then you would basically be undercutting one of the express statutory rights to extreme a degree. And so there's going to be a lot of dispute in this argument, I think, about what exactly the Supreme Court was saying in Campbell, whether Google versus Oracle sheds lights on this issue. There's going to be a lot of the doctrinal dispute that we're accustomed to. But I think in a case like this, what's really going to move the justices, they're going to look at those pictures from the brief, and they're going to decide for themselves whether they think pop art and Andy Warhol are so significant part of American culture that of course it can't be infringement for him to do what he did, or he's going to look at the other, or they're going to look at the picture of Miss Goldsmith, and they're going to look at the other pictures in her brief with Bob Dylan and all these other people, and they're going to think, well, how could Andy Warhol not negotiate with Miss Goldsmith here, who's kind of a sympathetic, less famous person, I dare say, than Andy Warhol. And they're going to say that that's too far, and then they're going to write the opinion, I think, to get to that result. Unfortunately, this is going to be a dispute that they have without Justice Breyer and Justice Ginsburg, who were two of the court's longstanding, I'd say, copyright experts, who often viewed these issues very differently and were on opposite sides of copyright debates. And we're going to have a bunch of opinions from people who haven't really told us what they think about copyright law or even intellectual property more broadly. So it'll be definitely an interesting case to watch, not just for the Prince lovers among us, but for the copyright nerds as well.
Yeah, for anybody who listened into the Google versus Oracle argument, definitely what Michael said about Justice Breyer is true. He was a very, very active questioner that day, and had some very interesting hypothetical situations that he had to offer. I want to ask a real quick follow-up question, Michael, on this case. There was, I think, at least 5 or 6 briefs that were for neither party among the amicus briefs. How much of an impact do those kinds of briefs have? Are they seen as more credible because they're not supporting a position? And kind of what's the purpose of doing for neither party?
I think that those kinds of briefs, and I confess I haven't looked at them all very closely because there are a lot of amicus briefs in this case. Often what those briefs are doing is telling the court, please be careful here, because if you say something that's too far to either extreme, it could really screw up a whole big area of the law. And all of the, or not all of them, but I'm sure a lot of those brief writers have this issue come up in very different contexts. I mean, obviously, if you look at Google versus Oracle, fair use of copyright code is going to be a very different inquiry than a fair use of an entire photograph. And I think a lot of the purpose of those briefs is to just signal to the court, tread a little bit lightly here. Remember that this is kind of like a fact-intensive inquiry. There are 4 factors, everybody's favorite kind of thing, a multi-factor balancing test. So just please be careful and recognize that there are other interests at stake besides Andy Warhol's foundation and Ms. Goldsmith's.
John, any thoughts on that?
I think it's funny you talk about Oracle versus Google. I know it well because I argued right after it in the undercard that day, or at least the follow-up. I do think you tend to see a lot of neither party briefs when it comes to academics and others who have something to say about the field but don't want to throw their weight behind somebody. I think also in the Andy Warhol case, it's you see a lot more neither party briefs because a couple of the very large intellectual property organizations and industry groups have a policy of not filing explicitly on either side, even if their brief, if you read it, sort of doctrinally lines up with one part or the other. They just have an institutional interest in saying they're neither party. So I think the combination of that is why you see so many neither party briefs in this case, in that case.
Albert, any thoughts?
Yeah, I was just going to add, I mean, I think at the end of the day, it does come down to the substance of what it is, but oftentimes you'll see in these neither party briefs, sometimes in the more technical cases, right, people coming in with some kind of a more expert explanation or an explanation of how this sort of field works or this kind of stuff works. I in my experience, I think that can be very helpful to the judges and the justices, especially if it is couches on either party, because then it's like, okay, we're trying to be sort of neutral. We just want you to understand how this works so that you can, have a background. I mean, things is like, right, like, I mean, if you have a thing about boats, it could be just someone who's like, this is how these boats work, right? And sometimes you'll see that in either party brief. That I think can be very effective.
So we'll stick with Michael as we turn to 2 cases that raise pretty similar issues, but involve different independent agencies, the Cochran case and the Axon case. So what are the questions in those 2 cases, and what are the far more impactful constitutional concerns that lie just over the horizon, depending on how the court rules?
Yeah, so the issue that's in front of the justices is a question of subject matter jurisdiction. The question is whether federal district courts have the power to consider a constitutional challenge being raised by private parties that are currently subject to administrative proceedings. And in these 2 cases, it's in front of the Securities and Exchange Commission in Cochran and the Federal Trade Commission in Axon. And both of those commissions are part of a broader statutory framework going back many decades that gives parties who are aggrieved by the administrative process a right to petition for review directly in the federal courts of appeals. So the way it would work is if you get a cease and desist order from the FTC and you think the FTC is wrong, then you go to the Court of Appeals and you explain why. What these parties want to do is go straight to district court while the administrative process is still running its course to argue that the way that these agencies are structured is actually unconstitutional under the separation of powers. And many agencies are set up this way with petitions for review directly in the courts of appeals. It's not just these 2. So the underlying dispute that Cochrane and Axon would like to raise in front of the federal district court is a dispute over whether the administrative law judges who are kind of presiding over the administrative proceedings in their cases are unconstitutionally insulated from the president's removal authority. So the administrative law judges are removable only for cause, and not by the president, but by either the commissions or the Merit Systems Protection Board or some combination of the two. And the members of those sort of supervising authorities, the commissions and the board, are themselves only removable for cause. And so there's this 2 layers of for cause removal protection that under some of the Supreme Court's cases, especially the free enterprise case, raises a separation of powers concern because the president's too far removed from being able to supervise these executive branch officials. So that's what they would like to argue, but the constitutional question is not actually before the court. Instead, the courts of appeals, the Fifth Circuit in the one case, and I think it's the Ninth Circuit in the other, yes, issued conflicting decisions about whether the statutory review frameworks for both agencies impliedly limits the general federal question jurisdiction that district courts have to adjudicate constitutional issues and other issues. And the United States government is arguing that the private parties need to exhaust the administrative process if they have an objection to what the agency is doing, and in the usual course would be able to raise these kinds of arguments in their court of appeals appeal, if any. And both sides then make arguments under the current doctrine, which looks at a variety of factors, such as whether the challenge that the party wants to raise in federal district court is collateral to the issues that the agency is investigating, whether the issue is outside the agency's area of expertise, and whether the challenger can get judicial review in another way. But I think at the end of the day, these cases are most likely to turn on whether the justices think that having to wait to raise these kinds of constitutional challenges at the end of the administrative process effectively denies meaningful relief to the challenger for what may actually be a constitutional violation. The challengers basically argue, look, making us wait years subjects us to the very process that we're claiming is unconstitutional, and we may settle, before then, because a lot of times these agencies have a lot of power that the private party doesn't really want to gamble being on the wrong side of, and so they settle to make the charge go away. And then if you wait to the end of this process, you can't really go back in time and cure the problem. And I think the court has seen in a variety of cases raising separation of powers issues like removal and the appointment power, private parties who have valid separation of powers claims that end up getting very little, if any, practical benefit after winning at the Supreme Court. So I would guess that the same justices who have been leading the charge in those cases are going to be a bit troubled asking these entities to wait till the end of the review process, which can be very costly and lengthy, but we'll see.
Is it fair to assume that it would be unlikely that there would be cert granted in this case if there weren't at least some justices that were interested in the underlying issue, which was the parties did request at least an Axon immediate consideration of that issue, but the court only granted on the subject matter jurisdiction case issue?
Yeah, I think that's right. I mean, this is a pace with, I think, the views of some in the court, particularly Justice Gorsuch, but others as well, that are really skeptical of agency adjudicators over Article III courts. Article III courts are independent, they have life tenure, and I think just a belief in Article III judging as the way that things that significantly impact your livelihoods or liberty or finances should really be decided. And there is a fear, and these cases always seem to pop up from the SEC and the FTC, that the in-house agency adjudicators are really just extensions of the prosecutors, which are in turn extensions of the political folks who call the tune at the top of the agency and who are going to be the ultimate deciders. These cases don't seem to bubble up, for instance, from a FERC rate case, where they also have an in-house ALJ system that resolves these issues. It really is from these agencies that are viewed as using their in-house adjudication system to circumvent what otherwise would have been done in the district courts. And I think one thing that's notable about these kinds of cases is, the FTC and the SEC can bring cases in the district court. It's they're opting for their in-house adjudications, which I think creates a lot more skepticism of it. And so, I do think we're going to maybe see something in this case about the benefits of Article 3 supremacy and the need for the neutral adjudicator. But I think what we're going to be seeing from the media injustices is how do we do that while also not creating ripple effects on. I do not think there are a lot of district judges in this world that want to now start taking on FERC rate cases. Like, they're just not. So, how do we draw lines to cordon off the things that we're worried about while not, while not eliminating the benefits of initial agency adjudication in other areas?
The two related issues of federal authority that have split the circuit courts are whether the Justice Department can dismiss a False Claims Act suit filed by a private individual after DOJ has declined to participate, and if so, are there limits on that authority? In the Polanski case, Elbert, how do you think that the court will resolve this circuit split, and why is this case such a big deal to government contractors?
Yeah. Let me just sort of take a step back to kind of make sure that everybody understands what we're talking about. You kind of hinted at it. So False Claims Act cases, as people may or may not know, are cases that can be brought there by essentially, whistleblowers, people, private parties who bring the suit in the name of the government, alleging that a government contractor, usually somebody they've worked for, has committed some kind of fraud on the federal government. So it's sort of undisputed in these cases, in these key TAM cases, where the person who's bringing the suit is called the relator, is really trying to vindicate the interest of the federal government. And what the False Claims Act statute sets up is, when these relators bring their suits, the government is given notice and they have some period of time to decide whether they want to get involved. And if the government decides to get involved, then they sort of take over the litigation. I think everybody kind of agrees with that. The question here is, what happens if the government declines? So someone's brought a private party, has brought the suit alleging fraud on the government, and government says, you know what, we're not gonna get involved, but so the case then proceeds. But then they decide sometime later in the litigation that they do want to get involved. And not only do they want to get involved, they want to dismiss the case. So to start with sort of the back part first, why is this case a big deal to government contractors? Well, the government contractors who are the ones being sued for the alleged fraud on the federal government. It's a huge deal if the United States is essentially deprived of its ability to come in and say, after they've looked at the case for some period of time, they've let the string play out, if you will, and then they've decided, what, this isn't really a case that we care about. It's our interest that's at stake here. We're the real party, and we want to make it go away. And if the plaintiffs here, if their position were to prevail, and they take what I think is fairly characterized as a pretty extreme position, just when you compare it to what the courts of appeals have done, they would say that once the government has declined that intervention at the outset, it has no power to dismiss that case ever over the objection of the relator. And so it is a huge deal. Now, how is it going to come out? That kind of gets it's I'm not a False Claims Act lawyer, so I've come to it a little bit fresh. And so I'll tell you, I'm not really sure. And here's why. One, the circuit split that's at issue, no circuit has taken the position that the plaintiffs here are taking, which is that the government has no ability, full stop, to come in later and dismiss a False Claims Act case if it declined to become involved in the first place. The split amongst the courts of appeals is basically just over what hoops does the government have to jump through, right? What do they have to intervene first, and what are the standards for that? And if they move to dismiss, like, are there certain, steps that need to be taken or hearings? Is there some level of review for the government's reasons for wanting to dismiss? But at a certain level, they all agree that the government has the ability to come in later and dismiss this case. And so what's interesting about this is the United States opposed cert here because they said that, yes, there is a split, but the split is really not that important to the sort of the core ultimate issue, which is whether we can do this at all. Their position in their brief is that the DC Circuit's position, which is that they should have, sort of great power to do this. They should be able to come in at any time, basically for any reason. It's essentially unreviewable because it's the executive's prosecutorial discretion that's at issue here. But even setting that aside, they said, look, but we can live with the split. And the court said, you know what, we're going to take it anyway. So that was interesting to me. And I'll also say, just not as a non-False Claims Act lawyer, I thought the plaintiffs have a fairly decent statutory argument, just in terms of like how the statutory structure is set out. Here's the flip side of it. For those who don't play in this space at all, there are some serious constitutional questions have been raised about this whole regime. Qui tam actions in general, where you have a private party essentially trying to vindicate the executive's prosecutorial interests. And so while on the one hand, the plaintiffs may have a decent statutory argument, there is a sort of a constitutional avoidance sort of lurking issue over if you were to take their position that completely excludes the government from being able to essentially decide what its own interests, how its own interests should be vindicated and carried out, that may run into some take care clause, Article 2 problems. So I guess at the end of the day, I would be surprised if there are the votes to take the plaintiff's position, but it is an interesting, the posture that it's come up in, when the fact that the court granted it, and the way the statute is written, again, for someone who doesn't do False Claims Act stuff usually, I'm not totally sure how it's going to come out, but I'd be surprised if the plaintiffs were to win.
One more case we want to get to, but Elbert has to jump off a little bit early. So I wanted to ask him this question because I think he has a unique perspective on it, which is a question about Justice Jackson. What impact do you think her having been both an appellate court judge and a district court judge, will that have on her performance and approach as a justice?
Yeah, I think it'll definitely have some effect. I mean, Justice Sotomayor also served as a district court judge, and I think you've seen a little bit of that in terms of, especially cases, civil procedure cases, or cases where there's some question of deference to the trial court, fact finding. How does that stuff work? You can see them bringing their real world understanding of how that works. I think you've seen that a little too with Alito, who was a prosecutor for a long time and kind of understands this is what it's like to make a record. This is what it's like to cross-examine. This is what it's like to, confront a witness. So I think you might see it in that context. So I think absolutely, the lived experience of litigating in a district court and having to exercise the discretion as a district court judge, I think will come through, not in every case, but in some. And I can hang out for another 5 minutes, but
yeah, thanks, Elbert.
thanks.
Last case we did want to talk about was Mallory versus Norfolk Southern Railway, which involves the court in another fight over personal jurisdiction. It comes to the justices from the Pennsylvania Supreme Court. What makes this case particularly interesting and important, Sean?
Sure. So Mallory versus Norfolk Southern involves the question of whether a state can require, as a condition of doing business in the state, that you register to do business there and have that registration to do business be deemed consent to general jurisdiction in the state. So in other words, you can be sued on claims not just arising from or relating to your activities in the state, but literally anything by anyone, anywhere in the world. And the argument is that because this is consent, the usual due process rules do not bar the exercise of jurisdiction. This was a thing back before International Shoe versus Washington, which is the seminal case on modern personal jurisdiction. It was back in the Benoyer era. And the question is whether this theory of jurisdiction is still good law. Now, you might say, if this has been around since before international shoe, why is it only coming up now? And the answer is because of how the court has limited general jurisdiction in the past. For a very long time, the consensus among practitioners was that if you had continuous and systematic contacts with the state, you could be subject to general jurisdiction regardless of this consent or registration notion. So if you were a big international business or national business like Norfolk Southern, you thought you were subject to general jurisdiction most places in this country, and you didn't think too hard about the issue of personal jurisdiction. In a case called Daimler AG versus Baumann, and then in a later case called BNSF Railway, the Supreme Court confirmed that general jurisdiction isn't that broad. It's generally only where you're incorporated and headquartered, which meant that you couldn't bring cases in the kinds of forums where you used to. And I think it's no surprise to anyone that there are certain forums, among them Philadelphia, others including Madison County, Illinois, or St. Louis, Missouri, that are thought of as particularly plaintiff friendly. So you have people who can't find Madison County on a map suddenly bring their cases there. And so the plaintiffs' bar, in an attempt to sort of claw back the jurisdiction that Daimler took away from them, have been making this consent by registration argument. It hasn't seen a lot of success after Daimler, in part because it's a quite obvious end run around Daimler. And so most states that have confronted this issue have said, as a matter of our state corporate registration statutes, which practically all of which say nothing about personal jurisdiction, we just don't think that our state statute creates this kind of quid pro quo. What set Pennsylvania apart is that it, at least, there are arguments that it's not even particularly clear either, but there are arguments that say it at least says that by registering to do business, you're subject to general jurisdiction. So you get rid of the statutory problem. And I think everyone thought that the Pennsylvania Supreme Court, which is thought of as quite plaintiff friendly, would uphold its statute. It didn't. It actually found it violated the due process clause, which then set up the Supreme Court review that we now see. So I think there's two big implications of it. One is just what I've been talking about, which is what is the future of personal jurisdiction after this case? Because if they find for petitioner in this case, you're going to have, every state in this nation requires registration. Not all of them deem that to be consent to registration, but some do under old cases, and in the states that don't, there's going to be a lot of pressure to amend your statutes to allow it in the wake of this decision if it comes out. And that's going to be troubling, I think, for corporations that really have enjoyed some success in personal jurisdiction following Daimler. The second part, and I think what makes this case interesting, is really what it means for methodology, advocacy, and just the ascendancy of originalism at the court. If you briefed this case 5 to 10 years ago, it would all be about, tracing the lineage of these cases from Pennoyer to International Shoe and forward. And what you would be saying is, the plaintiff would be saying, no, International Shoe in the later cases didn't overturn these older Pennoyer cases. And the plaintiff would say, and the defendant would say, yes, they did. This is all just in the ash heap of history. Your doctrine has moved on. That's not how this case has been briefed. I think picking up on Justice Gorsuch's concurrence in the Ford Motor Company versus Montana Judicial District Court case that I had the privilege of losing 8-0, he said, one thing we're not getting in these cases is a look at the original meaning of what the due process clause means. And there have been scholars, most notably Stephen Sachs, who's now at Harvard, who has really been pounding the drum of essentially Pennoyer versus Neff was correctly decided, and International Shoe is an abomination to the original meaning of the 14th Amendment. And so what the Petitioners Council here has done, and I think has done quite expertly, the folks at Keller Postman, this case is, they've made this case all about just like, what did states do in the 1800s around the time of the enactment of the 14th Amendment, and what did their statutes say? And there are long historical appendices, and they're fighting back and forth in the briefs about, well, maybe the statute says this, but the statute was interpreted this way by the New Jersey Supreme Court in 1905. And like, it's not a way of briefing a case that anybody would have done previously. Previously, you might have thrown out like 2 pages about originalism on your way through talking about the cases, and now it's the centerpiece. Everyone talks about the doctrine, but if you read these briefs, it's all different. I mean, perhaps the best example of this is if you pick up the United States Chamber of Commerce amicus brief, which, and I say this with great love to my friends at the Chamber, they would have done a little bit of doctrine, and then part 2 of the brief would have been, if you rule for them, it's bad for business. their brief is just all historical analysis and defending, the international shoe under the 14th Amendment. It's just a different way of approaching cases because there's this feeling that people who might have otherwise been reliable pro-business votes can be swayed by originalist arguments. And you need to go lock up those votes in a way that you haven't before. So how the court rules in this case, I think, is going to say a lot about, and it also says, quite frankly, about what this means about being a pro-business court. It's always thought that a court that is majority Republican appointed justices is quote unquote pro-business. But as the Republican Party itself is not necessarily reliably pro-business anymore, how is that going to translate out to the court as well? And I think all of this is packed into one very nerdy personal jurisdiction case, and that's why I'm keeping my eye on it.
Hope everyone enjoyed their law school flashback hearing Lawyer versus Neff, those of you who went to law school. So Michael, were you surprised that the Solicitor General filed a brief on Norfolk Southern's side in this case?
I think the SG's position in this case is actually very consistent with its position in prior cases, especially on the general jurisdiction issue. As Sean was mentioning, cases like Daimler and Goodyear, those were cases where the SG filed very similar briefs. And a lot of the time, and they say this in their motion for divided argument here, they want to make sure the court's aware that having expansive rules of general personal jurisdiction can create some international tension for the Department of State and the executive branch more broadly, because foreign companies are like, how could we possibly be subject to suit in every state that has this kind of a regime for issues that had no connection factually to that state? It creates some friction, and so that's one of the ways in which the U.S. interest here happens to align with the defendants as well.
So this is one case where the business community is going to miss Justice Ginsburg. She was an expert in this area, and I think a very level-headed spokesperson for the concept of personal jurisdiction.
And this is another case where we have a lot of neither party briefs filed on the top side. You had a lot of academics come in, because I think one thing that's interesting in this case is, the plaintiff got this case up to the Supreme Court, but he's not the most sympathetic plaintiff for the consent by registration regime, because he lives in Virginia, got injured in Virginia, or was allegedly exposed to toxins in Virginia. And yet he's filing in Pennsylvania because, as his Supreme Court counsel told Reuters, well, his trial lawyers are located in Pennsylvania, and that's the only connection to the case. So there is sort of a middle ground that some of the academics are advocating, because what if you have the person who is, a Pennsylvania resident and maybe doesn't meet the usual test for specific jurisdiction for whatever reason, but at least you can think that the state has sort of an interest in providing a forum for its citizens. And so you're seeing some neither party briefs trying to sort of stake out that middle ground as a way to try to help them out.
Remind our audience that you can ask questions if you'd like by using the Q&A function down below the screen. Question for any of you who wish to join in. The long conference has already occurred yesterday, and we'll probably hear from the court sometime early next week on that. Are there any petitions that you have your eye on, either from that or from other conferences coming forward soon that sort of fit into this realm of sort of business interested issues?
I don't know if I have any on.
Elbert, why don't you go ahead first?
Yeah, sorry, Sean. I'll just give you one, and then I'm going to jump. So there's a climate change case out of the 10th Circuit, Suncor, where it's not the actual merits of the issue. So there was one before that was about whether a really wonky issue of remand and appellate jurisdiction, and now we're into sort of phase 2, which is whether these cases should be heard in state court or federal court, and whether the state claims as they are pleaded are really federal claims that should be heard in federal court. So that is one that I think was up at the long conference, and will be interesting to see what the court does. But with that, I got to jump. So it's very nice.
Thank you, Elbert. Really appreciate you being here. WLF filed an amicus brief actually in the Suncor case, if you're interested in finding that online. Sean, Michael, any that you're paying attention to?
I have nothing I'm paying attention to by name, but I think what I'm really going to be interested in is, just how much of a business docket is there left at the court? When there are 50 to 60 cases per year now. And so sort of once you do the major, everybody sues the president cases, sort of the major I'll call them culture war cases, for lack of a better word, you know, the free speech, the religious liberty cases. Once you have to decide once again whether something is an armed career criminal predicate, or, you know, the latest things going on with habeas, and you've eaten all that up, it seems like the court really does not have much room or interest on its docket for sort of bread and butter, you know, commercial, bankruptcy, patent, sort of the stuff that, you know, sort of administrative cases that are not what is the future of the administrative case, but it's more like, you know, this is a major FERC or EPA rule and we just need someone to tell us if it's legal or not type cases. And the splits are out there. I mean, plenty of cases with really great splits are up, and you write those petitions. And this is not just me complaining that they don't grant my petitions anymore, but, you know, even when I've been respondent and thought like, oh boy, like it's going to be hard to argue this isn't a split, and they still deny them. And it's really, I think, frustrating for a community that would just like some guidance in the more mundane areas of the law to see the court limiting its docket and not taking on these meat and potatoes business issues. So I think what we'll, you know, the question I think is maybe after some of the fireworks of last term and some of the fireworks that will come this term, will the court try to back off and take some ERISA cases, which I'd really like them to do, or are they just gonna, is this the new mix going forward?
Michael?
Yeah, that's a great point, and I second your request for more ERISA cases. I think we'll always have the FAA. The Federal Arbitration Act seems like it's not going away. I'm keeping an eye on what could be a sequel to last term's Southwest Airlines versus Saxon case, which I know WLF filed a brief in. It involves the exemption to the Federal Arbitration Act for contracts of employment of seamen, railroad employees, and other classes of workers engaged in foreign and interstate commerce. And Domino's Pizza has a petition saying that there's now an even broader split on the question of local delivery drivers under this exemption. So we may see something there. And I think for fireworks, we might be getting the case over Florida's social media law, which now is arguably in conflict with the Fifth Circuit's ruling that says that a state can prevent social media platforms from filtering out certain content that they don't want on their platforms, and that the First Amendment doesn't prohibit states from doing that. So that could be something that the Supreme Court's going to have to address in the coming months.
On the arbitration issue, the Supreme Judicial Court of Massachusetts just issued a ruling involving Grubhub that was on the side of the Grubhub there on the issue of the exemption for transportation workers. There's a new paper that WLF put out on that on our website as well. It was announced yesterday that the court is going to be allowing the public back in to listen to oral arguments. They'll be releasing their opinions once again from the bench rather than through an email. Thoughts on that?
Well, I think it's great. I think it's time, if not past time, to get back to business as usual, so to speak, for the court. I do think it's great that they're continuing the live streaming of argument audio, which they started when they went remote, and I think has been a great service to court watchers and to the public more broadly. So it's great to see them continuing that. There was some question about whether they were going to go back to their old ways of releasing the transcript in the afternoon, but it's good to see that they're sticking with the audio.
Yeah, I mean, it's terrific to see the audio is going to stay. And I think that's probably a great compromise between the people who want cameras in the court and the people who want to keep them out. And it's really such a public service, both for, quite frankly, the public and the bar, that I don't have to wake up at 5 a.m. and get myself over to 1 First Street and stand in the bar line to go see a case. And I did some great stuff when audio was happening. I mean, when they were doing the vaccine or test mandates and the healthcare mandates for my client, the American Hospital Association, I live tweeted both of those arguments and did sort of running analysis and play-by-play. And I think it was very helpful for people, and it was great for just my client, who was getting a million questions from member hospitals on like what's going to happen, and they could say, hey, did you know that our Supreme Court expert is running a live tweet on it? And I previously we did that same service, but I would haul myself out at 3 a.m. and hope to be one of the lucky 20 people or 30 people that gets a seat in the courtroom. And it's really a good benefit that you can provide.
So we have a question from Sean's favorite client. Speaking of ERISA, have you looked at the cert petition in ERISA Industry Committee versus Seattle, which involves whether state and local player pay laws that require employers to make minimum monthly healthcare expenditures for their covered employees relate to ERISA plans and are thus preempted by the ERISA law of 1974.
Yeah, I can't say I looked at that one specifically, but I do think ERISA preemption is just one of those worlds that keeps on giving. You know, more broadly, unfortunately, it's been frustrating because Washington State and Seattle specifically is one of those areas where they have been doing a lot of stuff in the labor and employment field that companies have really been trying to get up to the Supreme Court on various theories, Dormant Commerce Clause and others, and just have not seen much success lately. So, you always fear that this is going to be one of them. I think there were certain minimum wage laws that related to franchises that Paul Clement tried to get up a while ago. And I think also this is one of these areas where some of the pro-business notions of the court versus some of the federalism and local control elements of the court, that, there are some people on the court who say, like, Seattle, if you want to run your labor practice into the ground, that's sort of your prerogative. And that, I think, makes it hard to get the 4 to 5 votes you need to get some of these issues up.
Any last thoughts on the world of ERISA?
Well, I will just say back on the arbitration topic, there's actually an intersection between ERISA and arbitration. And I saw this Cintas Corporation filed a cert petition out of the Sixth Circuit on this question the other day. So a similar kind of topic that the court dealt with in the PAGA, California Private Attorney General's Act context last term, about whether ERISA is in some way in tension with private arbitration agreements that limit class action relief and similar forms of relief. So that could be another issue coming up at the court sometime soon.
I think we have reached the end of our discussion here. Thanks to Michael and Sean and Elbert for joining us today, and for everyone who joined us on the webcast live today. This will be available as an on-demand video for those who might have joined late or have colleagues that have an interest in joining us. Joining it, taking a look at it. And I guess I will say that when he was the chairman of our legal policy advisory board, the late Dick Thornburg used to be the moderator for a lot of these panels, and his last words were always "stay tuned." So echoing Dick's wise counsel, I will say to everyone, when it comes to the Supreme Court, stay tuned. Thanks, gentlemen.
Thanks so much. Appreciate it.
Glenn.